Assalamualaikum and good day everyone. My name is Siti Sohaila and it is my pleasure to present a case study entitled Keberkesanan Akta Tuan Rumah Inaban 1952 Kajian Kes di PAUIN Educational Training Center Polytechnic Tuanku Syed Sirajuddin Perlis. This presentation aims to discuss how well this act is applied in a real hospitality settings and whether it is truly protect the rights of both accommodation providers and guests. The Innkeeper Act 1952 is a legal framework that defines the responsibilities of accommodation providers, especially regarding the loss, damage, or theft of guest belongings during the stays. It also outlines limitation of liability in cases where negligence is not involved. However, this law was enacted more than 70 years ago, and it is crucial to question whether it is still fixed into today's modern hospitality environment. This study specifically focused on PAUIN, a government-operated accommodations facility within the Polytechnic. PAUIN regularly receive guests, including government officers that attended seminars, also students and families. Therefore, it serves as a local location to assess whether the Act is understood, practiced, and effective in protecting both the service providers and the guests. PAUIN Educational Training Center began its operation in 2010, offering 50 rooms for both internal and external guests. Due to its location inside the Polytechnic and its proximity to facilities such as a hall and seminar rooms, it often becomes the accommodation choice for visitors involved in official programs. This also makes it a relevant case study to observe the implementation of legal obligations in actual operation. To carry out the study, the researchers distribute questionnaire to 10 staff members and 20 guests that had stayed in PAUIN in February 2014. This questionnaire aimed to measure the awareness and understanding of the Innkeepers Act 1952. The result revealed that 100% of staff were aware of the Act, but many of them admitted that they did not fully understand how to apply specific section, especially Section 4, which relates to the 500 ringgit compensation limit and the requirement for guests to declare valuable store in hotel safes. Only about half of the staff that actually practice requesting such declarations, which show a lack of procedural consistency. Among guests, this situation was more concerning. While a majority had seen the ad posted in some areas, less than half truly understood its content, and a very few knew that they had to declare the value of their belongings to qualify for claims. Many wrongly assumed that the hotel would be fully responsible for all the losses, even if it was occurred inside their own rooms without any involvement of hotel staff. This finding shows that while the Act is present, its application is not systematic, and both parties are not well informed of their rights and responsibilities.
Now, I will continue present about issue of this case study. The main issue in this case study is related to several shortcomings found at Innkeeper 1952. Firstly, the liability limits set in this case study are not comprehensive. They only involve the loss or damage of guest belongings and do not cover physical injuries that may occur during the stay. Secondly, Section 4A only set a maximum compensation of 500 for lost belonging. This amount is no longer seen as relevant or reasonable given the value of the good and the current situation. Thirdly, Section 4b does not clearly detail the type and value of the good. This situation made it difficult for accommodation provided to protect them left from invalid or false claim. Lastly, there is misunderstanding and vagueness in this implementation of this act among employee and guests may do not understanding their respective responsibility and right, causing the effectiveness of this act to be questioned.
So, for the holding of the case, according to the findings, the holding of the case will be that the Innkeepers Act 1952, while still legally in effect, is effective in its current form to protect both accommodation providers and guests at PAU Inn. The ruling is based on evidence that from staff and guest surveys which demonstrated lack of understanding, limited application and outdated liability provision. The study found that the RM500 Malaysia liability cap is outdated. The study revealed that Section 4A of the Innkeepers Act 1952, which limits compensation for lost or damaged guest property to RM500 unless negligence is proven, is no longer suitable for today's context. Many guest belongings such as mobile phone, laptops and jewelry exceed this value. Both staff and guests agree that this amount is too low and does not reflect the value of modern possession. Therefore, the liability cap should be revised to match current economic conditions. Next, staff do not consistently enforce legal procedure. While all staff at PAU Inn were aware of the Innkeepers Act, the study found that only 70% actually apply its provisions in their daily operations. Furthermore, only half of the staff took the necessary step of requesting details such as the value or care instructions when accepting guest items for safekeeping. This inconsistency was linked to a lack of proper training and clear operational guidelines. As a result, the legal protection intended by the Act are not being fully implemented in practice. Lastly, guests are unaware of their rights and responsibilities. The majority of guests surveyed did not understand key parts of the Act. For example, only 25% were aware and accepted the RM500 Malaysia compensation limit. Even fewer, only 15%, understood the need to declare valuable items with specific details before handing them over to hotel staff. Many guests also did not realize they could claim full compensation if loss or damage was caused by the hotel's negligence. This lack of awareness makes guests vulnerable and weakens the protection the law is meant to provide.
Now, I will continue the rationale of the holding. The first one is work procedure for declaring valuables. Section 4B requires guests to declare value, but doesn't explain how or when. This causes inconsistency at check-in counters. The second one, no requirement to list item details. The Act does not ask guests to describe items, like whether it's a laptop or a jewelry, only to give a value. That's make it hard to assess loss accurately. The third one, guests may misreport or omit item info. Without clear rules, some guests may hide or lie about what they store, leading to disputes or denial of claims. Besides, front desk lacks a standard form process. There is no mandatory form or process for staff to follow when guests declare valuables. This weakens enforcement and record keeping. The next one is liability limit doesn't reflect real item value. 500 may have been enough in 1952, but now it's far below the cost of common valuables like phones or laptops. The last one, guests are unaware of their responsibilities. Many guests do not know they must declare item or how the acts work, which causes misunderstanding and legal risks. The conclusion is although awareness of the Innkeepers Act 1952 exists among staff and guests, the Act is not fully practiced at power in. Staff often lack proper enforcement procedures and guests are unaware of their rights and responsibilities. The current 500 liability cap is outdated and does not reflect the value of modern personal items. Therefore, there is a strong need to revise the Act to today's hospitality environment, enhance staff training, and improve guest education to ensure better protection and clarity for both parties. Thank you.